All right, good morning. As you know, we've been talking about this presentation for probably 4 or 5 months. And a lot's happened, obviously, in the last 4 to 5 months, generally with respect to Title IX. So this is pretty timely, and obviously a lot more already going on, even yesterday, in terms of the last couple days of
I was going to say the last 4 or 5 days.
So that's 4 or 5 days, Sixth Circuit decision, and some changes that will have an impact on some of the stuff that Donna's going to talk about. I'm excited because I get to actually learn as much as you probably do about Title IX from Donna. And Donna McElroy is one of my colleagues out of our San Antonio office who practices it both in the higher ed level and some of the K-12 arena on the employment side, does a lot of also work with private employers on employment issues, but has done quite a few of these Title IX presentations. And I've had an opportunity to work with Donna over the last couple of weeks to kind of tailor a presentation to you as authorizers that you can then share to the schools. And I think, again, a lot of this is focused on the schools. But I think in your role as authorizers, obviously, we want to make sure that even though you're not directly involved in that Title IX process, you need to understand what the process is, how it works, and to be aware of things that are going on in the school so that those at the school can follow through. So I think, as Donna's going to tell you, this is more of an interactive process and presentation. We've got a lot of slides. There's a lot to cover. But she's going to want to make sure that if you have questions, please ask them. It's going to be an engaging conversation. I know we've got some exercises at the end, which are really also fun. We'll break up into smaller groups. So with that, Donna.
Good morning.
Floor is yours.
Good morning.
How is everybody on this beautiful morning? I'm so happy to be here. I can't even tell you because I live in Texas. And when I got off the plane yesterday, I sent Len a note before I even got in the cab and said, oh my gosh, the weather's beautiful. I'm not leaving. So I'm very happy to be here. So as Len said, this is really designed to be interactive. I have a lot of slides, but if we don't get to all the slides, what's important is we get to your questions and talk about the issues that you have concerns about. I tell people I'm a lawyer, so I'm used to people being rude to me, so just interrupt me, because if I'm in the middle of something and you got a question, chances are somebody else in the room has a question as well. So it will not throw me off my game if you interrupt. So what are we going to talk about today? We're going to talk about the evolution of Title IX and kind of talk about some historical aspects of it. We're going to talk about some fundamentals in the policies, the standardized policies that are provided to the schools. We're going to talk about some interaction with federal and state laws. We're going to talk about the shifting landscape at the Department of Education. I was actually reading an article this morning about something even new that's happening. And so at the end of the day, while we're doing this training today, and I think it's going to be important and a lot of it will remain relevant, know that change is probably on the horizon and we may need to do a refresher at some point. We're going to talk about some notable cases and some case studies, and obviously this is designed for this group. So like I said, ask questions if you have them. So what is the evolution of Title IX? Really, Title IX started in everybody's brain about sports, right? Equity in sports between men and women. And it was actually passed in 1972. It was signed into law by Richard Nixon. And it really didn't get a lot of fanfare. And then all of a sudden, when it gets passed, all of the athletic coaches and the high school principals came out and said, well, if we follow this law, it's going to impact male sports. I mean, in those days, they actually said that kind of stuff out loud, right? And so there was a lot of push-pull with respect to it. There was a case that went all the way to the United States Supreme Court where they said, all right, it only applies to programs, the actual programs that are receiving federal funds. So the sports programs weren't receiving federal funds, so it doesn't apply to the sports programs. In 1987, Congress passed a law that wiped out that Supreme Court case and says it applies to any institution receiving federal funds. And for the first time in 92, I think it was, they finally came out with a Title IX athletic manual for investigators. Again, everybody's focused on the athletic piece of it, right? And then what ends up happening is the United States Supreme Court thereafter ruled that and we'll talk about that, ruled that you could bring a private cause of action against a school that violated Title IX, and of course more attention started to get paid to it. We had a tremendous expansion of Title IX and how it was viewed as it relates to sexual harassment, sexual assault under Obama's administration. Trump has kind of pulled back from that, and we'll talk about that in a little bit more detail. But what does Title IX say? You know, for such a simple law, that has such a simple statute, it's created a lot of controversy, right? It says no person in the United States shall, on the basis of sex, be excluded from participation or denied benefits of or be subjected to discrimination under any educational program or activity receiving federal financial assistance. That's the nut of it, right? That's all of it. So to say it another way, is something preventing a person, and note, it's a person, not a student, not a faculty member, from enjoying or participating in the benefits or opportunities that the school offers. So if you keep that idea in your head, is something preventing someone from enjoying the opportunities and benefits that our school offers, it could be a Title IX issue, especially if it's based on sex, right? And so I mentioned this. This is the case, the Davis case. The United States Supreme Court decided that you had a situation here where a young girl, fifth grader, had been harassed by another student. And it was the facts were pretty bad. She was inappropriately touched. He rubbed his body against hers. He made lots of vulgar statements. And the mom made a bunch of complaints, and the school did nothing. And so they brought a lawsuit. And the Supreme Court said, look, damages can be rewarded if the school is deliberately indifferent to sexual harassment that they have actual knowledge of. So the school has to have actual knowledge of, right? And that harassment denies the victim of access to the educational opportunities. Again, same idea. What are the educational opportunities? The school is not responsible for the actions of the harasser. A lot of people don't realize that, right? So it's a little different. You probably have heard about Title VII. It's a little different than Title VII, right? Because the school's got to be deliberately indifferent and have actual knowledge of it. So if the people don't complain and the school tries to take action, they're not going to probably be responsible. But if they ignore it, then that's going to fall under the deliberately indifferent standard. So the coverage of Title IX, right? This comes out of the OCR Q&A, which is still in effect from 2014. A school must process all complaints of sexual violence, regardless of where the conduct occurred, to determine whether the conduct occurred in the context of an educational program or activity. So this is the guidance where schools have started investigating problems that have occurred off campus, right? Whether somebody's on a field trip, although that would be a school activity, but if somebody is at a party and something happens at that party. This is what I will tell you. The news article this morning that I just read says Betsy DeVos may be changing this requirement to investigate things that happen off campus. So more to come. Whether or not I think that I would advise you to investigate something that happens off campus is going to depend on the facts and circumstances. Even if they say it's no longer a requirement, there may be situations that come up where you say, now we're going to look into this because we're going to see if it's affecting and has it happened in the context of an educational or program or activity. So here are the fundamentals of Title IX. It covers, as I said, on and off school property or campus, residence halls and off-campus housing, off-campus parties, field trips, away events, football games that happen at another school, things like that, conferences, internship, alumni activities, trips abroad. It's very, very broad coverage as to what Title IX can implicate. So what happens under Title IX? If you get a report that someone has been harassed or treated differently because of their sex, whether they're a man or a woman, they've been sexually harassed, sexually assaulted, anything of that nature, there are mandatory reporters under Title IX. And mandatory reporters are defined as responsible employees who have authority to take action to redress sexual discrimination or persons whose students reasonably could believe have authority or responsibility over such matters. So again, you got to get in the head of the student, right? So in my mind, if a student's talking to teachers or staff about an experience they've had that might violate Title IX, they've been sexually harassed, you have a duty to report, even if confidentiality is requested. You have a duty to report even if confidentiality is requested. We might not always investigate it. In a case of a minor, we're going to. If they're an adult, they get the opportunity to say whether or not they want it to proceed, but that does not alleviate you of your duty to report. And what I try to tell people is, look, and I'll talk about this a lot today, which is err on the side of reporting, right? I can generally fix a problem I know about. I can't fix a problem I don't know about, right? And so that's, I think, a lot of what we're trying to do here is to make sure people are aware of the issues so that they bubble that problem up so it can be addressed. So right now, Len's going to take over.
Yeah, I want to talk about this because I'm going to bring it back. Part of the challenge we have with Title IX in working with Donna was how do we fit it into our model, right? So you're here as authorizers, you're not here as administrators of the school, though we're recording this and hopefully some of your schools will benefit this, and that's why it's being sort of delivered as if you were at the school and you were looking at this as a Title IX coordinator or others are on the board. But let's talk about just, and I know this is a really crude drawing, but it took me a matter of maybe like 2 days to come up with the basic drawing, right? Because I'm like, well, I could put a management company in here and I could put a, anyway, this is, so I ended up with this basic drawing, right? If you think about it. So if we think about Michigan, who's involved in a Title IX activity? And I drew these lines, this sort of direct line with the school and the authorizer is our contract, right? So we have a contract obligation under state law that you're required to ensure that that school is meeting the terms of conditions of its contract and all applicable law. We've spent a lot of time talking about that, defining that. You're all aware of that. In terms of Title IX, there's a hashed direct line to the MDE because MDE, like a lot of federal programs, is the state educational agency. It has obligations as the recipient, as the state recipient for receiving monies that come to the state, federal monies. And a public school academy, as an LEA, has certain obligations for federal monies that they receive under whichever program you look at. And those programs are administered by a board of directors. Obviously, you appoint that board. Most of you appoint those board members. They are public officials. They oversee the activities and are responsible for the entity. And that board also, for specifics with Title IX, appoints a coordinator, and that individual is sort of the eyes on the ground that deals with complaints, deals with the process, training. And so we look at these, go through these, SEA, overseeing the program, authorizer, direct contract obligation under statute, and then the roles. So these individuals, and we talk about this in the context of charter schools. I want you to kind of, I simplified that. Donna's going to talk a little bit about some of the policies, and we pulled the National Charter Schools Institute policy. Most of the schools have adopted that anti-harassment policy, and so, as you know, when your schools go through that, they have to decide, are they directly employing their staff or are they contracting that staff through a third party? And so some of those issues are carried out by employees of a third party. But when we get back to the structure, these are the legal participants in terms of who's responsible for delivering Title IX programs. So I want to talk a couple changes that have made in the interaction with state law. A lot of you have heard me say this. If you look at 1300A of the school code, it requires all school districts to have a sexual harassment policy. The legislature never amended it to include charter schools, which is crazy as it sounds. But it was only as of 1995 they actually had to have that when we did the 96 school code rewrite. So I get this question every once in a while. Why are charter schools? We don't have a sexual harassment policy. Well, you do. You're required under all kinds of laws, state and federal laws, to have anti-discrimination, anti-harassment laws. And so we basically included that as part of a larger, broad catch-all. Some of you used to have contract provisions that had sexual harassment, sexual assault policies. We've sort of wound those all into the catch-all. It's all applicable law, and it does apply. There's a couple things I wanted to say, and we said this is a shifting landscape. I want to point out a couple bills that are currently working its way through the legislature. I'm pretty confident are going to get passed because they're part of the sexual assault package that the House and Senate have been dealing with in light of the Nassar activities and problems at Michigan State. One is the OK to Say hotline, which is, if you see what's going on with that, has been hugely successful in terms of getting out knowledge. It started as a hotline. Now we have apps, we have Twitter accounts, Facebook, you name it. You can pretty much make a complaint on any way, and is a confidential mechanism to do that. They are going to now expand that hotline to specifically require or to allow for confidential reporting of sexual abuse, assault, and rape, which is in the works and I expect to be passed this fall. The other one, and I mentioned this at the last council meeting, is the training materials, the sexual assault training and sexual assault and harassment materials for all schools. So there's 2 new code sections that are going to require the department to produce materials for distribution for 6 through 12 on sexual harassment and sexual assault training. There will also be required for boards to amend their policies on sexual harassment. So this, again, will filter its way through the National Charter School Institute policies for those that have them. And then in 2019 and 2020, there were all staff who are involved with how to respond to students of sexual assault or harassment will be required to go through some training. And that will include both employees of the school as well as employees of third parties.
All right, we'll get caught on the chair here. So what does your anti-harassment policy say? I cannot tell you the number of times that I've been in a deposition or actually met with somebody to prepare for their deposition in a harassment case, and I asked the executive, what does your policy say? And they look at me like I have 3 heads, right? They have no idea. The place you don't want to be, because if a lawsuit gets filed, everybody's going to get sued, right? Whether you're the authorizer, whether you're there or not. And so the place you don't want to be is somebody comes to you, there's been some kind of problem, some kind of complaint, and you go, wow, I don't really know what the policy provides, right? And so it's something as fundamental as reading the policy and knowing what it requires. And we're going to cover this policy in the next few slides, but it's also not enough just to know about the Title IX policy. There could be workplace violence issues that get involved in these kinds of situations. You could have a violation of the computer IT use policy. You could have violations of access to campus or dining facilities. So when these complaints get filed, I tell people, don't just focus on Title IX. Let's focus on what are our policies in general, and are other policies implicated, right? Because that obviously will impact how serious the situation may be. It may impact how you decide to come up with discipline and things of that nature. So don't just focus on Title IX. So under your policy, who is in charge, right? Well, the board appoints an anti-harassment compliance officer, also defined as a compliance officer or a CO under the policy, and in the slides I'm going to be referring to it as a CO. That person also serves as the Title IX coordinator and the Section 504 coordinator, so it's all kind of rolled into one position. This position is critical. Right? So you think about the person who gets appointed as the compliance officer as witness number 1. So we don't want a compliance officer who is known to be biased in any particular way, somebody who thinks that all this is a bunch of hokey stuff and we shouldn't be paying very close attention to it. We don't want somebody who's got a reputation for not being thorough, not being complete, right? We don't want somebody who's got a reputation for being dismissive of complaints that are brought to them. So picking the compliance officer is key. It also has to be somebody who's got the ability to have empathy and to communicate with people, right? Because as an investigation is going on, he or she needs to talk to both sides, the person who's complaining, maybe the parents, as well as the respondent and the parents of the respondent. And so that person has to have a skill set that is important in terms of their ability to interact with people, and as I said, to be complete and thorough. So that is a very important appointment, and I think a lot of people miss that. I mean, I've had several schools have had problems where the Title IX coordinator was sort of an afterthought. It was like, oh, that person already has a full-time job, but let's just give that person this title too, and they never go get the training, and they don't have the right empathy and things of that nature. So that's a very important issue. So who's protected under the anti-harassment policy? This comes right out of your policy, or the policy that Lynn referred to. These are all the protected classes: race, color, national origin. Sex under the policy includes sexual orientation and transgender identity. The law is really in flux there. So it's important to know that your policy is broader than arguably the law requires. Disability, age is except as authorized by law. Religion, height, weight, marital or family status, military status, ancestry, and genetic information. So some of these things are not necessarily part of Title IX or even Title VII, which is part of what this is, like the height and the weight, but this is specifically in your policy. So you need to understand that all of these categories are defined as protected classes under your policy. Yes, sir?
Could you go back to age?
Yeah.
When it says except as authorized by law, I'm trying to figure out what exceptions there might be.
So if you have to be 21 or 18 to do a job.
I was thinking the other end.
Yeah, exactly. Who in here is under the age of 40? Okay. All the rest of us are protected from age discrimination. So yeah, you got another box to check. But it's usually a minor, can't do certain jobs, things like that, right? So, okay, so the key prohibitions under the policy. Harassment is not tied to a protected class. There's a provision under your policy that just prohibits harassment in general that you should be familiar with, right? Obviously, sexual harassment is prohibited, and we're going to spend time on that. So I don't want to read all of this to you, but the point is, if sexual harassment is severe or pervasive enough that it impacts somebody's ability to get an education or to do their job, it's going to violate the policy. Right? It's severe or pervasive, though. A lot of people think it has to be severe and. So if you get raped, it's a one-time thing, and that's going to be severe, right? A lot of times, though, we're trying to figure out, is this pervasive, right? Is it somebody who's making jokes all the time? Are they touching people all the time? The more that you get that kind of evidence, the more likely it is to be pervasive. But it's got to affect their ability to participate in the employment, a class, or an educational program or activity, right? And it must objectively create a hostile environment that is sufficiently severe such that it adversely affects or limits a person's educational or employment environment. So it's all right out of the policy, but that's the idea to keep in your head is this conduct severe or pervasive enough that it's impacting the job, or was submission to this necessary for them to be able to do their job? The old quid pro quo thing. If you sleep with me, I'll give you the promotion. That kind of thing. We don't see quite that directly anymore, but obviously that's prohibited. The policy also prohibits these categories of conduct as well. There's a prohibition against bullying, race or color harassment, religious or creed harassment, national origin harassment, disability harassment. It prohibits stalking or cyber stalking or sexual violence, and all those are defined specifically under the policy that you can read. But I wanted to bring to your attention, essentially, anybody who's in a protected category or protected class is also protected from harassment because of that protected class, right? It makes sense. You can't discriminate against somebody because of their race, and you can't harass somebody because of their race, right? And any act of retaliation, again, this is a quote, any act of retaliation against a person who's made a report or filed a complaint against unlawful harassment, or who has participated as a witness is prohibited, right? So not only is the person who is complaining or the complaint is being brought about, Donna was being harassed, Len brings the complaint, right? Len's protected, I'm protected, and if they go interview Ron to see if he saw something, he's protected from retaliation because of it. And the reality is the last 3 jury trials I've had have all had a retaliation component about it. And here's what happens with retaliation is in juries, they really get angry about this because they say, look, you have these policies, you do this training, you tell people to bring complaints forward, and then when they do, something bad happens to them, right? There's an adverse action. Nothing makes a jury matter because they can say, you were right, that wasn't harassment, but the action afterwards was retaliation. So, you know, the coaching to do with your schools is, look, if a complaint gets made, don't overreact to it, right? Against an individual teacher or something like that. Just cooperate and don't take any action that looks like you're going to go after that person. To include trying to find out what people have said. Did you get interviewed? What did you tell them? What did you tell them? You know what? Stay out of it because it starts to feel retaliatory. And to me, they can be more dangerous cases than the original claim itself. And what's the standard for retaliation? The standard that's starting to get picked up in Title IX cases really comes from Title VII. And it's a Supreme Court case called Burlington Northern versus White. And the Supreme Court says, look, here's the standard. Would the action dissuade a reasonable person from coming forward, participating, or complaining? And the Supreme Court said context matters, and here's what that means. So take a situation where you've got an admin who comes in and she's got a child with special needs. There's one place in town where she can take that child for daycare, right? So her schedule is 7:30 to 4:30. Everybody else's schedule is 8:30 to 5:30. And so she files a complaint that she's being harassed. And after that, the boss comes in and says, you know, I went to this seminar that Donna McElroy did, and she said everybody needs to be treated the same. And so we're going to shift your schedule to 8:30 to 5:30 so that you'll be like everybody else. Well, the reality is context for her means she just lost her job because she can't get to pick her child up by 5 o'clock if she's got to work till 5:30, right? So were we aware of the complaint that was made, that she made prior to that decision being made, right? So context matters because now if people see she had to quit because her schedule got changed after she made a complaint, that is more likely to dissuade a reasonable person from coming forward. So that's kind of the standard, and it's being picked up in Title IX as well. So where are you likely to find retaliatory conduct? If you are talking to your schools and you know an investigation is going on, it's not going to be out in the open. Very few people anymore are, getting in people's faces directly. It's in the text messages, it's in social media, it's in emails. It's not out in the open, right? So we have to be asking. It's on Snapchat. Snapchat, my gosh, I can't tell you the complaints that have come out of Snapchat, but you should be asking for copies of those postings, screenshots, or asking people to forward it. Do not do this though. Do not say, "Oh, are you friends with Donna on Facebook?" Okay, good. Pull her page up and let me see it, right? Because if we're not friends on Facebook, he doesn't have permission to see my postings. But if we're friends on Facebook, Ron, not that Ron, has permission to see my postings, right? And he can print them and he can give them to you because you've got permission. But what you don't have permission to do is go online and let you see my page. So yes, sir.
Going back to the Snapchat, doesn't that go away? How does that work? Or would it be just the texting in the Snapchat part?
Excellent questions. The question is, doesn't Snapchat go away? No, it doesn't. Okay. So there's several ways. I've had a case where a student sent a Snapchat that she thought was going to go away, and the boyfriend takes the iPad and takes a screenshot of it. Boom, he's got her naked, right? And there's actually a program now that actually can capture it. And if you talk to your kids about it, there's other ways that they can save it, so it doesn't always go away. And that's frankly the danger of Snapchat. These kids are doing a lot of things thinking
It's going away.
they're sexting, right? They're sexting, and they think, oh, it's all going to go into vapor. Well, it doesn't. Sometimes it does, and that makes an investigation much harder, right? But not always. And that's really a big issue, I think, for kids because they don't understand how it really works, right? Oh, and the other thing on the guy who takes the picture, then it's on his iPad that he gets it off, right? So she's lost total control of it. She has no idea where it's going to go at that point. I didn't know I was going to have, when I got out of law school, I didn't realize I was going to have a specialty in smut law, but anyway. So who is protected under the policy? I mentioned this before when I said Title IX applies to all persons. So that means employees, students, vendors, anybody who's part of the community. So a vendor has a right not to be discriminated against who's coming onto your campus on the basis of their gender or the basis of their sex, right? That's how broad it is. So, more on policy requirements. I can't really emphasize enough how important this is, especially to me with K through 12, which is this. The students especially, but everybody else as well, but especially the students, need to know who the CO is, and they need to know how to contact that person. I bet you if you went to your schools and said to the kids and did a survey of the students and said, do you know who the compliance officer is? Again, you get that blank stare, right? So I think you need to be publicizing it. I think you need to err on the side of over-communication. I would implement, every school should be implementing, and I think you guys have the policy. How is it distributed? Who knows about it, right? And the policy should have, and yours does, we're going to talk about this more, it has investigation requirements. We have both an informal and a formal process, but if a complaint involves an academy employee or other adult with a student, it's always going to be a formal process. But the thing I see people fall down on the most is nobody knows who the compliance officer is, right? They don't know how to go get help, right? And the teachers who are not the compliance officers don't know how to respond, right? They don't bubble up that complaint that is possibly a Title IX violation. So how do you get the word out? You got to conduct training, right? For the employees and for the students and maybe even the parents. I had a situation this past year where frankly we had a bad guy, a pedophile, that we probably could have caught in this school had a parent brought to our attention a complaint her daughter made about him. He had not gotten over the line with her. She said, he's been a teacher there for a long time. We're just going to let that go. And then somebody else was hurt, right? Had we been training the parents to say, if you see something, say something, maybe we would have, the injury to that child would not have occurred. So think about whether you do training to parents. I do orientation sessions when the kids come in. Here's, if you got a complaint, here's who you bring it to, here's how you get a hold of them. I'd put posters up. I'd actually pass out flyers with contact information. So again, when you're trying to say we were not deliberately indifferent, which is what Title IX requires, this is the stuff we go through. We say, look, we're on it, right? We're communicating about it. We're making sure that this stuff gets brought to our attention. But the contact information should be, make it clear, who do they contact, when can they be reached, and how do they get help? At universities, we have these people be available 24/7, right? It's probably not, on a K through 12, you don't need it quite that extensively, maybe in high school though, depending, right? But all of that stuff should be made clear.
So
Yeah.
Is there any? Yeah, we can not break for a second. I want to go back to what I had mentioned earlier on some of the discussion that's going on in the legislature here, right? On specifically information out at the schools. And so, the sexual assault training and sexual harassment materials that are going to be coming into effect, if that legislation passes and it's part of a 26 bill package that's teed up for the fall, will require just that, the kind of dissemination of information that is being asked. And part of what happened, I think, is there's a belief that a lot of, to Donna's point, no one knows who the CO is. No one has that information on a regular basis. So I think there's going to be, if we see this in the fall pass, an ongoing effort to get that information out, not only in the handbooks, the parent handbook, the student handbook, the orientations, maybe separate trainings, specific posters in the schools about this so that kids know how, teachers and anyone at the school knows how to deal with those problems. And so I think, part of it, what I think a lot of legislators who were dealing with this issue found is that the state law was a lot, at least in the K-12 context, was behind, even though Title IX applied. some of the state law policies hadn't really caught up to that, and that's, I think, going to change.
Yeah, and I think the focus has been on universities. Yes, sir.
Any issues with, in the charter world, a lot of times these compliance officers will be employed by a private enterprise, a management company. Where in the traditional schools, they're kind of working directly for the school board technically. So they're kind of a public feel. Any issue with, you know, someone working as a contractor, as a building leader, or a superintendent? Even though they're working for a
Yeah.
public board,
Right.
I'm not a public employee.
So I think this is it's a good question. I think it's been a challenge with FOIA coordinators, anyone who we had this with chief administrative officers, you know, is this individual got to be a public employee? You know, I think a lot of it goes to looking at a couple things. One is the operations of the school are through that management agreement or service agreement. There are specific rules and responsibilities. And if I look at most of them, this issue of the Title IX coordinator, like say an Open Meetings Act or a FOIA coordinator, isn't really clear who's doing that, right? So it ends up being a policy issue at the school. I think you have to remember when those individuals take that responsibility on, they are actually performing a public role. And this is just like our teachers, even though they're private employees, when they step into the classroom and prior to that certification, criminal background checks, all those laws, they really, even though they are a privately employed person, they are a public school teacher. And I think that's the same situation we have here, which is individual could be an employee of a third party, but they're, for purposes of those duties, a Title IX coordinator and serving a public function and are subject to all the requirements as a public.
So there's no issue with, you don't have to have a board member be
Nah, I mean,
be your compliance officer. You could have a building leader or a
No, I don't think so. I mean,
Right,
there's
I think
nothing-
that, yeah,
we
I think
don't
it's a
have-
practical matter. As Lynn said, they're serving that function.
Well, we went through with CRI, remember? I mean, criminal history record
Yeah.
people that caught us.
Mm-hmm.
Whoops, you're not a public employee. You,
Yeah.
Right.
Yeah, no, so I think that's how they're practically functioning in this scenario. So again, staying on your policy still, who can receive a complaint? Whether it's formal or informal, the education service provider can receive a complaint. The school leader who's employed by the board can receive a complaint, obviously the compliance officer, but also teachers, employees, or building administrators. So simply because you're a teacher doesn't mean you can't receive a complaint that there's been a potential violation of Title IX or sexual harassment or something like that in the school atmosphere. So who has an obligation to report that to the CO when the complaint gets brought forward? As you can see, any administrator, supervisor, or academy official who receives the complaint shall, so it's mandatory, file it with the CO at first convenience. Now, we'll say there's a little bit of a disconnect in your policy that you probably ought to be looking at, because another part of the policy says all members of the academic community must notify the CO within 2 business days if harassment has been reported to you or you observe unlawful harassment of a student. I would counsel you to report it immediately, right? I don't know why anybody would wait 2 days, so I prefer the first bullet over the second bullet, but be aware that that's in there. And then the CO has an obligation to contact the students and or the parents within 2 business days of that complaint coming forward to them to make them aware of it, okay?
So quick question
Yeah.
then. So where is the authorizer in that chain? It's never happened. And, you know, and I hope it never happens to us, but so what if a parent called us as the authorizer? And so now, are we in the loop and are we, do we have that same obligation?
Len can tell you legally, I would tell you practically, yes,
Yeah.
right?
I think we've had this situation. I've talked to various authorizers. We've received anonymous complaints. We've received actual complaints, sometimes from staff, sometimes from a parent. Immediately reporting them back to, through that process. There's another piece of that to the extent it involves child protective services or any kind of child abuse, that reporting is immediate as well. They're mandatory reporters under that, so that's usually to the county number, and that there's a form you fill out and you do that. So I think, you know, to Donna's point, and this the challenge with this presentation was we had to pull a policy that a lot of your schools would have. We could have taken one school's policy, been kind of unfair to that school because we could have, but we took the National Charter School Institute policy, which had sort of that broad policy. So to the extent for schools that don't have that policy, they can obviously look at that, but that covers a lot of different issues.
And what we see, and frankly, I think you might start getting more complaints to the authorizers, because sometimes if somebody is in a school and they think that, you know, the school leader's not going to take any action against this beloved teacher, they want to get out, right? They want to get out of they don't want to go to the compliance officer. They want to go to somebody else that has to answer, right? So I actually think as all of this stuff develops, and I'll show you a slide about more complaints against K through 12 organizations, you guys might actually get more complaints, right? And so you, as an authorizer, we're going to talk about this, ought to have a mechanism for how you're going to address it, right? Are you just going to take it back down to the CO, or are you going to do something different? If it involves, in the school board, I'm jumping ahead, but if it involves the school leader, right, the school board might want to get an outside investigator to come in and look at it and not have the CO. There's all kinds of things you would consider in that situation. Again, back to the policy. Obviously, I said before, the policy prohibits bullying. If a school leader believes that the conduct might have created a hostile environment as well, then under the policy, the school leader is required to report that to the CO, and the CO is to investigate whether it's a harassment issue based on gender. And if so, you suspend the bullying investigation, so there's just one investigation.
Hey, Don, I'm sorry to interrupt.
Yeah, no problem.
I can't quite get beyond that yet. So if we do receive a complaint, it doesn't, I'm struggling to try to wrap my head around going back down to the school level CO. So what would an authorizer's next avenue be?
Well, I think you probably a discussion with the board is what I would think.
Yeah, I think, you know, sometimes, let's say that the problem is the CO.
Right.
Is the
Right.
individual.
Some of the schools
Right.
don't want administrators.
So sometimes, and you know, then the question is, what are the other avenues? And Donna mentioned directly dealing with the board dealing with their counsel. A lot of what's going to happen, particularly if this is an investigation, is going to have to be done on a confidential basis with, you know, someone representing the school's interest, protecting that entity and that board in terms of that process and making sure that it's fair to all involved. So that'd be an example, and you know.
And these are going to be really driven by very fact specific, depending on what you're presented with, right? The cases that scare me the most, I think you said some of these schools just have one administrator. Mm-hmm. Those are the kind of cases that scare me the most. Is you got one administrator and who's really got eyes on the ground as to what's going on in the school. So Title IX's purpose, as you all know, it's been in the news for quite a while. The Title IX the purpose is not to tip the scales for one side or the other. But I will say that some of the training materials that came out after the 2011 Dear Colleague letter started to be used against schools as evidence of gender discrimination, because the belief was the scale was getting tipped too far to the person who was making the accusation, and was not giving due process to the person who was being accused, right? And so there's all kinds of stuff that you can read about. They want you to do what they call a trauma-informed interview of the person who's coming and bringing complaints. She says she's been sexually assaulted. There's this concept of tonic immobility. And the concept is that when you go through some sort of tragic thing like that, you get sexually assaulted, that you can kind of just shut down, and you can give people lots of inconsistencies, and you can tell stories that are not, you know, tell you one story, then tell you another story, and get it all jumbled up. And there are professors out there who say those inconsistencies shouldn't be counted against women when they're in this place. It's actually tied to an animal reaction when it's like fight or flight, or you're going to shut down, and they go through all these things. And so the question is, you know, is it tonic immobility or was it exculpatory evidence? In other words, she's telling an inconsistent story, so should that affect her credibility. And many schools for a while were saying, no, we shouldn't rely on those inconsistencies because of some of this science that is floating around out there. As the courts are starting to get these cases, they're saying, no, of course, you make credibility calls, right? And inconsistencies are the kinds of things you look at to see whether or not somebody is telling the truth or not. The role of the CO is to make credibility decisions. That's the role of the CO, right? And so I don't know how you can make those credibility decisions if you're not looking at inconsistencies in statements. Now, that's going to be very hard when the children are young, right? Because getting a straight, I have 3 kids, so getting a straight story out of kids when they're 21 is hard, much less when they're 6, right? And so, but I do think it's important for you guys to know we need to make credibility decisions. And the case that came out literally 4 days ago in the Sixth Circuit, which governs Michigan, the Sixth Circuit has said that that the person who has been accused has a right to cross-examine the person who is accusing them directly. I will tell you, probably none of the policies, and this policy included, doesn't have a provision where there's a hearing where somebody can cross-examine in front of the person making the credibility decision. I'm not really sure how that's going to all play out, but be aware that the Sixth Circuit has said very clearly that is a fundamental due process right. That is contrary to what the Office of Civil Rights wants people to do because they don't want the one person to have to be re-traumatized, right? But your landscape just shifted pretty significantly last week when that case came out. Yes?
This tonic mobility,
Yeah.
is that gender specific?
Well, that's the argument. That's why I said, is it junk science or is it reality? It is. The argument is women are more likely to shut down, men are more likely to fight or flight, right, to get out of that kind of situation. And so the argument they're making is that, you know, she was sexually assaulted and she kind of quit fighting. She just let the guy do what he was going to do because her tonic immobility was, I'm going to go quiet, right? So again, I don't know that there's a lot of valid studies on this, but it's certainly a theory that's floating around.
I guess I can understand the moment, but afterwards, you know, I just don't see that. I think a man could shut down just as much as a woman. So, or a young, especially if they're younger.
Yeah.
So,
Right. I agree with you, but the theory is they've been traumatized and so it carries on, right? I don't know how you can, you can manage, if you will, if you don't look at things like they're making inconsistent statements. Otherwise, you just have to ignore what she says, right? And just say, okay, she said she was sexually assaulted and stop there. Well, I don't think you can do that. It's not fair to whoever's being accused, right? So what are the CO requirements under the policy? I think it's important for you to be aware of what it says. They obviously have to be available during the work or school hours. They begin a formal process or an informal process depending on how they want to proceed, or they can designate somebody to do it. So they don't have to do the investigation themselves. Somebody can be designated. That we ask for a complaint to be brought within 30 days of the incident, but we will investigate complaints that are, that happen outside of that limitation. The formal complaint, according to the policy, ordinarily must conclude in 15 business days. That is very fast for a formal complaint because we're going to go through what happens in a formal complaint. So if I'm thinking about this policy, I'm thinking that I'm not crazy about 15 business days, 3 weeks for a formal policy, but a complaint to be looked at. I mentioned this before about identifying the correct policies. What am I really looking into that's been violated? I say speed kills in the sense that sometimes in somebody's vigor to go look into something, they miss it, right? They miss important evidence and they don't ask the right question or they don't talk to the right witnesses or they decide not to talk to a witness that the respondent, the way your policy is written, it's the complainant and the respondent. And the respondent says, go talk to Lynn. I don't need to do that, right? And then had he done that, he'd have had information that might have exonerated the person, right? So I think you have to be on it, right? We don't want to delay things, but you have to be thoughtful. Also, collaboration may be important. I think when people do these investigations in a silo, Sometimes they miss things, right? And so maybe there's a faculty member that needs to be talked to about, hey, what's really going on with these kids? Tell me about the relationships in the classroom. How is it working, right? So I don't like investigations done in a silo. So under the policy, if somebody can do an informal complaint, they can come in and say, look, this guy won't be quiet, and he's continuing to say things to me. And yesterday he came up and started rubbing my shoulders, and I just want it to stop, right? Well, if both parties agree, then we can do an informal process under the policy. However, as I said before, if it involves a student and an adult, it is required to be a formal process. Sometimes the CO might advise against an informal process. If somebody has actually been sexually assaulted or physically assaulted, they may advise against it. That's allowed under the policy. What are the range of options? Talking to the person. I will tell you this, if somebody's just really a lech, sometimes just having the conversation, hey, Laura, knock it off. Donna doesn't think you're funny. Quit making those jokes. I'm sorry, I didn't know. Okay, I'm done. That kind of thing. She was standing in the crowd and she laughed like everybody else. Well, she felt uncomfortable calling you out in front of the crowd, right? Sorry to pick on you. And so obviously, reminder of the policy. The policy allows facilitation between the two people with a third party if the CO thinks that's necessary. At any time during the informal process, it can be terminated and moved to the formal if somebody gets dissatisfied. And this one needs to be done, again, within 15 business days of receiving the complaint. I'm not bothered by that on the informal process because it's more about kind of trying to mediate it immediately and see if we can't get it resolved. Len mentioned this. If you have a complaint, an outcry statement from a child about child abuse, that you have a mandatory obligation to report that. And this is how your statute is written. If it's a child with a disability under the age of 21 or a child under the age of 18 who has suffered or faces a threat of suffering, physical or mental wound, disability, or condition of a nature that reasonably indicates abuse or neglect of a child, to immediately report knowledge or suspension to the county services agency, right? So Michigan's law is a little different because you've got an obligation to immediately report. Like in Texas, it's 48 hours. So that's a higher burden that you're held to. And similarly, what is similar to other statutes is you don't have to know that it was actual abuse or neglect. If you suspect abuse or neglect, then you have this obligation to report.
So one thing that, again, this is another one of those areas that is under review and expansion. So as you can imagine, there's a bill that would expand the mandatory reporters to include paid coaches, assistant coaches, and athletic trainers. So that is still up in the air, but there will be additional. The initial House bill had volunteers, and as you can imagine, for any volunteer in any organization that deals with kids, that got kind of pared down. But I suspect we're going to see some expansions of that term, academy teacher and employee, to include specific mandatory reporters for those involved with athletics and school training, any kind of therapy. I mean, obviously therapists and others are mandatory reporters, but for trainers, athletic trainers being added.
So a lot of times people will say, okay, we've called Child Protective Services, so can we stop the investigation? The way the policy is written, the CO needs to continue the investigation about what was going on in the school unless in consultation with the educational service provider or the school leader, they come to a different decision. But the CO doesn't have the authority just to stop the investigation him or herself. They have to make that in conjunction with those collaborations. What happens if you fail to report? It's a misdemeanor, punishable up to 3 months in jail plus a fine. And as I said, the standard is suspected, not actual. Okay, so what happens if somebody says, I want to go through the formal process? Well, with the formal process, what the policy requires is obviously the CO's got to keep both sides informed. Remember, I talked about those communication skills. A written statement is requested but not required. If they get a written statement, generally what they're asking them to do is to take the notes and ask the complainant to validate that that's what the complaint is. Then they have to consider interim steps, and I'll talk about that in this next slide. They need to decide who all they need to interview, what witnesses do they need to go talk to. Obviously, consider any documentation or information that's brought to them by either side. And again, it says attempt. It's not required, but attempt to complete in 15 business days, which is with a school schedule and semesters. And generally, these things happen like the day before spring break, right? I mean, you get the complaint in spring. You're like, yeah, you got your bags packed, you're ready to go, and you're like, okay, now, right? So that's why I say that 15 days is awfully fast. Because then the CO is required to prepare a written report of his or her findings and give it to the educational service provider or the school leader. And within 5 days, the school leader or educational service provider must issue a final decision. So this is pretty fast in terms of how quickly this stuff is happening under the policies. Interim steps. This is a pretty controversial topic because the way the Dear Colleague letter was written, the interim steps would be, okay, somebody makes an allegation against me that I've committed sexual assault. I get removed from campus and I get removed from the class where the person is that I allegedly sexually assaulted. Well, again, as the courts are starting to see this, they're like, wait a second, that's not due process. I mean, I've just been accused. That's all that's happened, right? I've not been found to be responsible. And so while interim steps need to be considered, we need to balance both sides, both the person bringing the complaint and the person who's responding to the complaint. But some of the things you can consider are basically issuing a no contact. Like a CO would issue a no contact and say, okay, you guys, I don't want you to have contact with each other. I don't want you to text each other. I don't want you to, come and, I just don't want you to see each other. Stay away from each other. Reassignment or removal from classes. Interim suspension was talked about a lot. I think you have to be very careful about that from a due process standpoint. Obviously, if it rises to the level of a criminal activity, you can report to law enforcement. And all of these interim steps can apply to faculty or staff as well. If the faculty member is a problem, he or she might be, asked to go do something else for a while. But they can get reassigned as well. The claimant does not have to agree to the interim steps under the policy the way it's written, and the CO may take any action that he or she deems appropriate in consultation with the service provider or the school leader. Another critical role, I touched on this a little bit, is what is relevant. A lot of times I'll get a case and somebody will say, he didn't sexually assault her, she sleeps with everybody. Okay, well those two things are relevant, right? If she consents to sleep with people, that's her decision, right? But if she doesn't consent, that's sexual assault, right? So as you hear about these things or investigations, if you hear of things that don't seem right in terms of what's being considered, that's how we've got to guide people, right? It's not always relevant. The relationship with the respondent is probably relevant. The relationship he or she has with other students, maybe not. What level of responsibility is there for what happened, right? In terms of were they drinking? Were there drugs involved? Who was doing what? Who was the aggressor, and who was the person receiving the aggression? Are grades of a complainant? Okay, that person's a bad student. I don't know that that's relevant to whether the person gets sexually harassed, but people want to bring that up all the time, right? The respondents, what we get on the respondent side is, what he or she might have done in the past, right? So that's a big question. If somebody, as a freshman in high school, got in trouble because he was shooting spit wads at some girl or something, does that come into the consideration of the CO for some complaint that gets made when the person's a senior and maybe the conduct is worse? These are very nuanced decisions that have to be made. I think the prior acts should not be considered unless it looks like it's the same kind of conduct, right? I think there's got to be a distinction made there. Whether the person's a good corporate citizen and does a lot of volunteer work and works in the community, again, if they're at a party and there's, drunken sex, I don't know that it matters if the person does other good works or has good grades, right? But one thing you got to assume if you're the CO, if it's allowed in the record, people are going to assume you use it. See, I'll get some investigators who say, I just let everything come in. I let everything come in and then I make a decision about what's relevant or what's not. Well, if you get in a lawsuit then they're going to assume that you used irrelevant information to make your decision because it's in the record, right? Why'd you allow it? What the focus should be: what policy was involved, and was it violated? And does that evidence help us answer those two questions, right? What policy was involved, and was it violated? And does what they're bringing forward allow us to answer those questions? Beyond the rules, communication issues. So you've got some requirements for the CO to do a written report when it's a formal investigation. I will tell you, every email, every text message, every post, Instagram, whatever, is going to be scrutinized if a lawsuit happens. And so the warning I guess I would have for this group is, if you hear about an investigation, be careful of your emails. Be careful of saying, I can't believe this has happened. I don't even know what that means, right? Or no way that faculty member would do that. Because those kinds of things become exhibit number one. Because the truth is, you don't know, right? You're not there. So take the information and don't make promises you can't keep, right? Don't predict the outcome of the investigation. Don't predict what the sanctions might be. And remember that the respondent has confidentiality rights too. I tell people that, let's see if it's here. You know, when I work with COOs and CEOs of big companies, their emails are like one sentence. Okay, let's meet. All right, glad to hear that. All right, when are we going to have that meeting with, client ABC? They're not putting, diatribes in emails for somebody later to take shots at them over, right? When you get into these investigations and somebody's communicating with you in an email, less is more. Pick up the phone. Okay, can we talk about this? I do have to educate my children every once in a while that's actually what that was originally invented for, the iPhone, to actually speak on the phone. But people in our world, it's like, I'll just send you a quick text. All that's discoverable, and all that gets scrutinized. In 2020, it always looks worse than it was when you're in the moment, right? Obviously, more investigation tips. I want the COs to be actively engaging in collecting the evidence. Don't wait for it to come to you. Hey, I heard that Ron has this text from Len. Well, go ask Ron if he's got the text, right? Can I see it? I'd like a copy of it. Deliberately strategize about when you're going to talk to the respondent. I don't always go from the complainant to the respondent. Sometimes you want to talk to the other people who might have been around and might have witness some of the conduct, so that when you talk to the respondent, you've sort of got more of a global story about what the person's being accused of. Consider the timing and location of witness interviews. Kids are going to make up, if they're all sitting in a room waiting to be interviewed, they're going to get their story together. It might not be the right story, it might not be the truthful story, but they're going to come up with a story. So think about where you're going to interview people, how you're going to bring them in. Structure, obviously, the investigation such that you can protect student privacy. And then when this CO is done, he or she should have a very clean investigation file. They should have, get rid of the irrelevant evidence that's in the file. Be consistent about drafts or revisions. Some people keep all of their drafts, and some people do a final report. You can go either way. Just do it one way, right? So because the time that you decide I'm going to get rid of all the drafts, or the time we're going to have a lawsuit, and then we're going to find out in the prior investigations they kept all the drafts, right? And then if you keep the drafts, then they need to note why they make changes to the drafts in the document contemporaneously with it. So my preference generally is to come up with a final written report and get rid of everything else and say, here it is, right? And obviously, the report should also have a copy of all policies that were implicated or potentially violated as a result of the conduct. This is, I can't tell you how basic this is, but I have had a case where somebody went in and interviewed like 15 people and never wrote down the date and the time and the actual person that they were talking to. And so when it got to my desk after it had blown up, we had to reconstruct who are all these people that you talk to, right? So very basic kind of things. You don't have to type the notes, But if you're writing it, if you're handwriting it, let's make sure everybody can read it, and we know who you were talking to and the date that it happened. Obviously, the other kind of point about interviews is, I like to interview on a neutral turf, so to speak, or at least someplace where it's not, a fishbowl where it's like, oh, Donna's in the principal's office, look, something must bad happen. So think about those kind of privacy issues. I would caution people that they should not be talking about the investigation, that could, in some case, result in a defamation claim if they're talking about things that aren't true. But it also could be a policy violation, because to the extent someone who is a witness goes out and starts talking about it, they could trip themselves into a retaliation claim, right? Is that they feel like they're going to go take up for their buddy, and they're going to go talk to the person saying, I can't believe you're bringing this against John. Well, that could arguably be retaliation, and so people should be warned about that. I would flow chart the witnesses if you talk to a bunch of them, so I can remember who led me to whom. And again, emphasize that retaliation will be taken very, very seriously. When to involve your own lawyer. I promise this isn't a commercial. The reality is some of these things require a lawyer to be involved. By and large, because the only thing that's really confidential anymore is the attorney-client privilege. So I will be taking somebody's deposition. I'll say, what'd you guys talk about? Oh, it's confidential. We agreed it was confidential. Well, guess what? You get to tell me unless your lawyer was there, and that lawyer was there to provide you with legal advice, right? So if a situation is particularly sticky, you may want to bring your lawyer in so that these conversations can be under the Maxwell Smart cone of silence. I'm dating myself, I realize. But that way you can talk about the good, the bad, and the ugly, and really understand how best to fix the problem. And so, so keep that in mind. Like I said, everything is discoverable, except that. Lawyers talk to lawyers. If you get a call from a lawyer saying, I'm representing Donna McElroy, you say, fine, let me get my counsel. I don't like administrators and school leaders and teachers talking to lawyers. That's always a recipe for a bad outcome. And then obviously, if they're starting to ask for records and there's a discovery process, generally you're going to want your lawyer to get involved in that. Parent communications. Be careful when talking to parents, because parents don't always have all the facts. They know what their child has told them, right? Mom, David sexually assaulted me. That she leaves out the part that, we were at this party drinking and smoking weed, right? And so be careful about those communications. Again, don't overpromise, right? Don't offer opinions about the person who's been accused. Yeah, that kid has been in trouble since the day he came to school. I really don't. Let's not say that to the parent of the mother of the child who's making the accusation. Don't disclose prior disciplinary action. Don't advise them not to get a lawyer. I can't tell you how many times this comes up as a fact in one of my cases where the parent is upset and says, the parent of the person who's making the complaint says, well, the teacher told, or the dean told me not to get a lawyer. And then we get to this hearing and he's got a lawyer. I would have had a lawyer had I known he was going to have a lawyer, but I got advised by the school not to have a lawyer, so it looks like you're interfering. If they say, well, I'm going to go get a lawyer, you know what? You need to do what you've got to do, and you've got a right to go do that, right? Because it just makes it look like we're trying to cover something up, right? And as I said, don't speak to their lawyer. Do understand that everybody understands what the policies and procedures are, both sides, both the person who's bringing the complaint as well as the respondent. Okay, under your policy, if an appeal is allowed, and it's not always allowed, either the respondent or the complainant may appeal. That must be done within 5 business days of the written decision of what the sanctions are that were going to be imposed. And then the board can, by the way, at any time the board can pursue an investigation even if a community member does not, if they think that there's grounds to do so. So if we thought we had a threat, if we thought we had somebody who was actually a broader threat to the campus community, the board itself can engage somebody to conduct an investigation outside of the CO like we were talking about before. Obviously, like I said, the board can have an external person perform an investigation. What's interesting in the policy is there's no stated grounds for an appeal. I would recommend there be stated grounds for appeal. Generally speaking, things like new evidence that didn't exist at the time of the investigation. Not just I want the board to hear it all over again, right? There ought to be some sort of standards for that. And then the board within 20 days needs to meet with the parties and their representatives and then issue a written decision within 10 days. And again, under the policy, at that point, the board's decision is final. So did the sugar show up?
Yes.
Okay, because this would be a good place for a break if we want to take a break.
Yes.
Okay, awesome.
Great.
Okay, I'm going to shift gears a little bit to kind of move away from the policy and talk about some statistics. We're going to talk about some cases. Interesting, the U.S. Department of Justice says nearly 20% of girls ages 14 to 17 were sexually victimized in the year 2015. During the 2007-2008 school year, the DOJ and the DOE reported that there were 800 reported incidents of rape and attempted rape and 3,800 reports of incidents of other sexual batteries at public high schools. In 2012, the CDC found that nearly 30% of female rape victims were first raped between the ages of 11 and 17. So this is not just a college problem, right? I mean, this is a K through 12 problem. And this may be a little hard to see, but I talked earlier about there are increasing numbers of complaints that have been brought against K through 12 schools. If you see back here in 2009, there were, this is Obama, I think this is the first year of his administration, there were 11 complaints brought against K through 12 schools. And then you'll see it consistently goes up to 24, 22, 16, 31, 21, 61, 83, in 2016. So while the top bar is universities, and obviously they're getting a whole lot more, it's going up. I mean, it's gone from 09 to 2016, it went from 11 complaints to 83 complaints. And as more people are getting educated on the fact that they have rights under this, I think we're going to see more and more claims get filed. More statistics, 44% of attacks take place before the victim enrolls in college. Children who experience sexual violence are almost 14 times more likely to experience rape or attempted rape when they get to college. That's according to the National Center for Victims of Crime. And as I just said, you know, the first year of Obama's presidency, OCR had 11 claims, 83 in 2016. So 269 complaints over that 8-year period. And then the sort of the frightening stat is 80% of the guidance counselors, when they're surveyed, say they feel ill-equipped to handle this kind of stuff. So again, that's what this training is about, right? We got to get it down to them so they know how to handle these situations. I think this can be a game changer. Bystanders issues, right? See something, say something. Universities are having great luck with this kind of training, right? It actually started in the military because there was a lot of harassment in the military. But the point is, look, we need bystander engagement, because if you're doing something that offends me, I have to say, stop doing that, right? It becomes adversarial in nature. But if you say, hey, don't do that, it's not funny, right? So then all of a sudden it's like, oh, okay, well, everybody's backing off. And so the idea of bystanders training is that you're trying to change the social norms. It's not funny to make racist jokes. It's not funny to make sexually innuendo type jokes, right? And that everybody's involved in creating the environment that we want to live in. And I think I really do think it could be a key to getting real change. Now, the other thing I think you got to think about, though, is in some of these situations, giving the students immunity. So the kids, let's say they went on a field trip and somebody brought the bottle of vodka and everybody consumes the vodka, and we need to figure out what happened. So you got to say to the kids, look, you're going to have immunity from a expulsion or suspension standpoint for the alcohol violation. We might make you go do some alcohol education, right? So it's educational versus punitive, but we need to know what happened. So you got to think about that so that they're willing to participate as well, right? But a recent study showed that when they did this bystander training, that the university students not only immediately changed their attitudes, but also continued to have an impact a year later. So back in the school level, again, I think the teachers ought to be talking to the students about this kind of stuff. Okay, if you see something, say something. Bring it to the trusted adult that you trust, right? And if you did something wrong in connection with that, you were not supposed to be in the band room, and y'all were all in the band room. Okay, fine. You're going to have immunity from that, but I got to know what happened. So how can these investigations be limited? We often get the reluctant complainant. Somebody will come in and say, man, there was a crazy party, or we were on this field trip and, we're not really sure what happened, but we think something bad might have happened to Donna. And you come talk to me and I'm like, I'm not interested. I don't want to be involved. I don't want to go forward. If I'm an adult, you've got to respect that. If I'm a minor and you think that I've been sexually harassed or sexually assaulted, then we have an obligation to look into it and investigate it. Obviously, this can get very complicated on a small campus when you've got 2 students who are in that kind of situation and fighting. And the other places where you can be limited is if the respondent is not a student. If something happens and that person is not a student, obviously your ability to investigate that is going to be fairly limited. Some people think that they're not responsible if an incident happens abroad. I would tell you if it's a school-sponsored incident that happens abroad, Title IX is going to apply. And some people have said, well, if the conduct occurred way in the past, 2-3 years ago. Ideally, if I'd have done this a year ago or 2 years ago, I would have probably said, yeah, if it's way deep in the past, then it's really not something we can look into. Now my advice is, even if it's 2 or 3 years old, we need to at least try to look into it. Again, because the standard we're going after is that we're not deliberately indifferent. So if we just dismiss it, hey, she didn't come forward for 3 years, this can't possibly be a credible claim. Yeah, that goes into your thinking, right? It's going to go into whether or not you think it's a credible claim, but you got to go ask her why she didn't come forward, right? Was she threatened because the guy's brother was still at the school and he threatened to beat her up and now he's not at the school? I mean, it could be all kinds of things. My message is we just can't turn a blind eye to this stuff, right? If we hear something, I think what society and the law is telling us, we have to at least look into it. What happens if the student lawyers up? I had an investigation the other day where the guy walked in with his lawyer and he took the Fifth through the whole thing. Well, taking the Fifth Amendment, right, your right against self-incrimination, that's a criminal concept. This is an administrative proceeding that we're talking about. Now, you can't, if they're not going to say anything, they're not going to say anything. But I think the fact that they take the Fifth can be used against them as you're making your credibility determination as to whether or not you think they violated the policy or not. I do think that's and I do try to push back a little bit when the lawyer shows up and I'll go, this is an administrative proceeding. We're not in a court of law here, where there's no judge. And sometimes you'll push back and the lawyer will let them talk. And the reality is I think that this does a disservice to students. And we had a well-known criminal defense lawyer in San Antonio. Whenever the kids would get in trouble at a local university there, he would come in and let them talk. And that always worked out better. He said, I'm not worried about the administrative piece. I'm worried about if there's a criminal, and I'll take care of that. So, but just to be aware, I do think it has to have an impact on your determination because they're not giving you their side of the story. What do you think is the biggest complication in sexual assault cases? Or what makes determining consent, a difficult determination? The involvement of drugs or alcohol. I mean, these cases, by and large, although I had one that was an interesting case that I'll tell you about in a minute, but by and large involve drugs and alcohol. And right, so when did somebody consent and when did they not consent? And these decisions are tough to make. The other thing that can be complicated is you could have a respondent who has a disability. He or she could be on the spectrum of any kind of particular disorder. You might have to give that respondent more time to answer. You might have to get a support person for that respondent sooner. Sometimes, people with certain disorders don't understand social cues, right? And they don't understand affect and those kinds of things, and we've seen that. Dating violence, I call it the sleeping giant because it is. Because what happens in dating violence is somebody gets beat up, they go make a complaint, and 2 days later, you're in mid-investigation, and they're out. They're like, I don't want to pursue that anymore. I'm done, right? And if it's an adult, they've got the ability to say, I'm out, don't investigate it, unless we think there's a threat to the community. Very, very difficult cases. Sexual harassment cases involving faculty that are tenured, very complicated cases. A lot of times what we're trying to do in those situations, frankly, if we think it's going to not go well for the faculty member, is just talk about, why don't you just go on down the road and decide you're going to go work someplace else, as opposed to he's shaking his head there. That's how it's been.
I've dealt with it.
Yeah. Yeah.
Now it's really just allowing that predator to go down to another district, so you dealt with it.
Right.
So
I
one
don't
of
like
the
that.
things, to talk about this, because you're talking about disclosure, part of this bill package, as many of you know, there's a requirement for unprofessional conduct checks. Section 1230B of the school code talks about you have an obligation to get a statement from the applicant that they have, they've not, been dismissed for, and that lists the unprofessional conduct and the charges. Legislature's currently putting together a bill that will make that, set up a database for those dismissals where you can go in and check against that. It's not done. It's a very controversial bill because it's the cost to maintain the database will be significant for the state, but the state would have an obligation to provide that information on a confidential basis for future employers about whether or not an individual is dismissed for certain conduct. And so again, part of the challenge that's coming with some of this disclosure is, you're right, people have been dismissed, they go to another school, and we've seen it in the charter school world. They're like all public schools, and I think the legislature is going to start to address this issue.
Now, Lynn, didn't we just see something though where the governor or somebody in Michigan said that the box you have to check is gonna be gone from applications?
They
For-
committed a crime.
Yeah, you're talking
Felons.
about ban the box. You're talking,
Yeah,
Yeah, but-
for certain employment of the government, certain felonies will not be required to be disclosed. What I'm talking about is in the context of a public school teacher or any staff member being hired at a public school.
right,
So,
right.
yeah.
Yeah, but, and it's a challenge because frankly, the other side of it is sometimes a teacher is wrongfully accused, right? And it's a messy case. And so these are going to be push-pull things for sure. But when we get a case against a tenured faculty member, those can be very complicated cases because the faculty member's got a right too, right? They can bring their own lawsuit that they were treated inappropriately under the policy. You can also, a lot of times we get confusion about the criminal process. So someone who has obviously been sexually assaulted has the right to pursue a Title IX complaint within the school. They have a right to pursue a criminal complaint. They have a right to do both or neither. It's all, as an adult, again, as an adult. If it's a sexual assault involving a minor, then we're required to obviously notify law enforcement and to pursue an investigation. And then parallel investigations can take place. A lot of administrators will call me and say, why are we investigating this? The police are involved because we have a responsibility to. And we can't ignore that responsibility. Again, courthouse is different than our administrative procedure. And the burden of proof is different. At the courthouse, you've got to be proven guilty beyond a reasonable doubt, right? That's the highest standard of proof that we have at the courthouse. In most situations, and in your policy for a Title IX violation, it's a preponderance of the evidence, which means is it more likely than not that the person is responsible for violating the policy? It's like a 51% rule. The OCR has backed off of that and now said that you can have a clear and convincing standard in these cases. And I sort of asked the question, should we have a clear and convincing standard? I think probably not, because I think that's going to shift, it's going to shift the balance too much. Because the other thing is, am I going to have a clear and convincing standard for all violations of school policy or just the Title IX? Because then I make it harder to prove a Title IX violation than I do maybe a violation of the drug and alcohol policy or a dress code violation or whatever, right? So I think preponderance of evidence is sort of where it should stay. The other reason that you should not wait for the criminal investigation is, that can take years. OCR's average investigation time has been 2.2 years. Okay, so you got to get yours done. Also, the penalties are different, right? We can expel or terminate employees. A court can send people to jail. So they can run parallel, and one does not stop the other. Yes, ma'am.
Has there ever been like a situation where maybe it's almost seen as like the school leader or the CO kind of getting in the way of a criminal investigation, or somehow if they're doing something where it could be intrusive to that, where you're talking to witnesses and getting statements and they, I don't know, I'm just trying to see if there could be a conflict at certain points when they're doing something, if it goes to a criminal level versus what the school leader or the CEO is trying to do.
Right. I think you have to be in close communication with the authorities, right? You're absolutely right. The question for the audio is, is there a time when the school's investigation could essentially be interfering with the criminal investigation? That is a possibility. And so depending on how serious it is, you're going to have to coordinate that. I had a situation for a school where somebody was murdered off campus. And so we've made a very clear distinction that we were not going to have anything. We're not going to make a decision about that, right? It was by a non-student, but we investigated other student-related conduct that wasn't related to that criminal act. And so you've got to closely coordinate. I mean, the advantage like universities have is a lot of them have police departments now, right? And so you can kind of they have MOUs with the local authorities, and so they can do it in tandem. But that's a very good question, and I think it's something that you have to be careful about if the authorities have been contacted. And look, if the authorities say, look, we don't want you to get in the middle of it, fine, but you still have to look back from a broader perspective and say, okay, do we have other issues here that need to be addressed? Maybe not that distinct criminal conduct, but did I have a problem with other students and other policy violations that led to this, right? That stuff I think you can still look at, right? But you do have to coordinate it. If some of you, I think, have international students from time to time, so I just wanted to make sure you were aware that if an international student gets involved in a criminal situation like this, Title IX, and somebody goes and pursues a criminal activity, that could actually get them taken out of the country. And you must notify the International Student Office if something like this happens, whether it's a criminal conduct or whether it's Title IX, because they could have their visas revoked and be deemed inadmissible in the U.S. Another reason, when foreign students come over, they ought to be educated on this too, right? They understand what their risks are there. What is our ultimate goal with Title IX? Our ultimate goal is, look, if an incident is reported, it is the board's obligation to take reasonable steps to eliminate the behavior, prevent its reoccurrence, and address its effects, right? How do we do this? Well, we have a policy, we disseminate that policy, we make sure that we've got a CO who's trained in doing his or her job, and we talk about it. And then when something does happen, we take disciplinary action. I actually think one of the things that can help a school the most, if somebody comes in and says, you guys are discriminating against girls here, they don't have the same advantage, you've got this hostile environment. If I can actually, let me show you the discipline that we've meted out over this issue. And so it's not showing that I've got, it's that we take action. So taking action builds your record of saying, we're going to prevent its reoccurrence because we're taking action, we're doing something, right? And how you address the effects. And as well as educating the student body, we have to start talking about this stuff more. We have to arm students with the knowledge that they don't have to put up with being treated in certain ways, right? Talk about it. I wanted to talk a minute about interaction with federal laws because sometimes this comes up. Obviously, FERPA prohibits non-consensual disclosure of personally identifiable information from a student's school record. If you get federal funds, FERPA applies to you. The Clery Act does not apply to K-12. It applies to colleges and universities. The reason I raise it is there is some noise in Congress about whether the Clery Act ought to start applying to K through 12, which requires schools to put their crime statistics out there about what happens on campus and sometimes off campus through an annual security report. So that might be coming to a location near you soon. The Civil Rights Act of 1964, which is known as Title VII, we've talked about that some, right? Title VII and the Age Discrimination in Employment Act and the Americans with Disabilities Act, that's where all those other protected categories come back, that we're not going to discriminate based on race and color and national origin and religion, et cetera. So these two laws can overlap. And I think that most employees, when they decide they're going to get upset with the employer, they pursue it under Title VII. That's what we're seeing. I'm not seeing that many cases where a faculty member or a staff member pursues Title IX. They usually go to Title VII, which is the Equal Employment Opportunity Commission. So just be aware that there is some overlap. Okay, the shifting landscape I mentioned when we started, the Office of Civil Rights has had quite a lot of change since 2011. But if you are found to be not in compliance with Title IX, you can lose your federal funding. We haven't really seen that happen, by the way. But more common than not, they're doing these investigations, and then they get consent agreements called voluntary resolution agreements. And their latest tactic is now they want you to hire a third-party independent person to come in for a couple of years and monitor your compliance. And every complaint that gets made, that person gets to go to get involved with, which is frightening, to say the least, because then you've got somebody backseat driving in your school about how these things are being handled. But sometimes the school will settle because they don't want to spend the legal fees to fight it, and they agree to it, and it can cause problems. There was a spike in OCR investigations during Obama's administration. Under the Trump administration, we are seeing much fewer investigations. They have pulled the protection for sexual orientation and trans rights, but as I said in your policy, that's protected in your schools. And under the new administration, there is much more focus on the due process issues that we talked about a little bit earlier. This shows the spike. So the government has conducted 502 investigations of colleges. This is just colleges and universities for mishandling reports of sexual violence. So far, 192 cases have been resolved, 310 remain. So this is the date of what we call the Dear Colleague letter, April 4th, 2011, when they said we're going to change the landscape on how you look at sexual assaults. And you can see this is the number that's resolved, and this is the number that are active. And I have one, I was just telling Ron, I have one now that has been pending. The student was a freshman when it happened. She just graduated, summa cum laude, I might add. I mean, so she did great. And it's her dad who's behind the complaint. She's kind of moved on with her life. But it's been pending for 4 years, and it's still pending. And the client calls and says, well, should we call him? And I'm like, no news is good news. And this, hopefully it'll simply get dismissed. But it's a very arduous process. Like I said, it's 2.2 years. I just gave you an idea. Cornell's got 7 active cases. Princeton's got 6. Stanford's got 5, Indiana at Bloomington and Kansas State each have 5 as well. So it just gives you a little bit of an idea of sort of what's going on at OCR. So what were they requiring when they come in and do an investigation? It'd be curious to me to see if they do this in a K through 12 school. They were asking universities to do an annual climate survey where you survey the students and ask them what the climate is like relative to sexual harassment, sexual assault, treatment of those kinds of things. Obviously, they want people to designate a Title IX coordinator. I will say before the Dear Colleague letter in 2011, lots of institutions did not have a Title IX coordinator. It was just an afterthought. Obviously, they want the preponderance of evidence standard. That was what they were requiring under the Obama administration. Also, extensive and continuing training. The thing about training that you have to remember is, this is great. I think it's awesome that you guys are doing this. But you can't do this and then shelve it for 5 years, right? Again, because you've got kids coming through, every year it's a new crop. Some are coming and some are going. And so you've got to be, I think, doing annual training as it relates to these issues. Clear and consistent definitions as to what sexual assault meant. Opening it up to the dating violence, all of those types of things. Completing investigations in a reasonable time. Under the Obama administration, in spite of the fact that the OCR takes 2.2 years to complete their investigation, they were saying investigations should be completed within 60 days, which again is very, very fast when you're between semesters, right? And people are traveling and all this kind of stuff. And obviously responsible parties should report immediately. What has happened in September of last year, the OCR issued a new Dear Colleague letter with a new Q&A, and they rescinded the 2011 Dear Colleague letter as well as the 2014 questions and answers on Title IX and sexual violence. And they issued some guidance where we've got some question and answers, and they withdrew, as I said, the protection for transgender and sexual orientation. They have, Department of Education has indicated it's going to go through the regulatory process, so we're not going to have these letters, and they're going to engage in the rulemaking process for regulations. Have not seen them make a move on it. They've engaged in rulemaking for some other items, and in fact, about a month ago, they were like 9 things that they said they were going to do. This wasn't on it. So I don't know if they're going to just come back with the Q&A guidance, or they're actually going to have guidance, a regulatory process where we get to comment on what they're proposing. So more to be seen. Under the new guidance, as I said, responsibility in doing interim guidance needs to be balanced. You can't be making a decision that somebody did something that they've yet to be held responsible for. And some states, though, have laws, by the way, that mandate preponderance of the evidence on these. Does Michigan have one?
Don't know the answer.
Okay.
Yet. We'll look.
And so under the new guidance, they remove the fixed timeline, and they say you need to do these investigations in a prompt manner is what they use. And what they also now allow that they didn't allow under the 2011 Dear Colleague letter are informal resolutions of these issues. And so your policy already allows for informal resolution, but under the prior administration, they wanted no informal resolution. And I will tell you, we've actually had some really good successful outcomes, allowing the parties to get together and kind of figure out what is a good outcome. So I think that can be used, but it was previously barred in sexual assault cases. And then they also have added that the accused must be given notice of the accusations in writing. Believe it or not, under the 2011 Dear Colleague letter, the accused didn't necessarily have that right. So that's a big change too, which I think, again, everybody's got a right to due process. I had mentioned about if you've got kids who travel abroad. I think that it's unclear whether Title IX applies abroad, because if the statute says any person in the United States, but I'll talk about there's the legal aspect and there's the practical aspect. The practical aspect is I don't want you guys to be the test case, because here's how I think it sizes up. The factors I'm going to look at was the travel done through the school? Was there tuition paid to the school? Are faculty present? Is credit awarded? If there are faculty and staff paid to attend, and what we've been talking about all day, the political climate. I mean, I think that somebody might say, yeah, it does apply. Harder for you to investigate if something happens, but it does apply. Okay, real or fiction, I promise I've not made any of these things up. I want to talk about what happens in some of these things. So in this situation, when I say I'm not sure if the OCR has jurisdiction to things that happen abroad, well, I actually found 2 OCR investigations. One involved a private high school, and they actually were looking into whether or not Title IX had been violated, and they only backed out when they realized the school didn't receive federal funds. So that tells me they think they had jurisdiction. And then in this Yukon case, the student was in Spain, and she claimed that she had been sexually assaulted in an elevator. 2 guys had groped her. And they had an 18-month investigation before they settled it. There were other allegations, but the fact that her complaint happened overseas didn't seem to be a big issue for anybody. So in my mind, if kids are going overseas on school trips or whatever, here's what I tell people. Our policies apply wherever we are. Right? So if we're doing an organized educational function, then our policies are going to apply whether we're here or in Mexico. How we react is meaningful. I have seen cases that blow up because of poor communication. This gal was in Ireland, as I recall, and she claimed that she was raped by a third party, and the guy wasn't a student. And she wanted to speak to the 12 students the next year who were going to be traveling. And at the last minute, the dean cancels it on her and says, no, I don't think I'm going to let you do that. And even if you show up, I'm going to move the meeting and you're not going to be able to speak to him. She's like, that's strange. And then she files 2 Title IX complaints. Here's what she says in the paper. I don't want any survivor to deal with what I've dealt with. This has been a whole lot worse than the assault. This is when she gets back to school. Here's where they went wrong. Here's the allegations in her suit against the school are they failed to inform her about her rights and available resources. It didn't matter that it happened in Ireland. She's back. Let's talk to her about what we can get her help here. They didn't help her communicate with the Irish police to pursue the prosecution. They took months to respond to her request for assistance. Then she is smart enough to ask the school for a no trespass order, right, criminal trespass warning, because this guy lived near where they were going to the school. And the school does nothing with it, right, for like months. They don't ask her for a photo until the spring. And then when they finally put the photo up to let people know what her claim was, they put a photo of 3 guys and didn't identify which one it was. So she like blows a gasket, right, because of how the school handled it, you know. And then in the reporting, she's indicating I was not going to go to this route, but because of how it's been handled, I think my Title IX rights have been violated. So how we respond is meaningful in how we communicate. Bathroom walls and Facebook are a very dangerous combination. There were graphic drawings of a woman in a bathroom in an employee locker room. Some showed her being sexually exploited or assaulted. There were pictures of men there too, but none of them were naked or engaged in sexual activity. And the stuff was there for at least a month, was the evidence. And then there was photos of drawing posted on Facebook and the employees passing around a phone, sharing it at lunch, and one supervisor making a joke and laughing about it in a meeting. And when they went to investigate it, the manager said, "You just can't change stupid people." That was what that he said to the woman. Any idea what happened? Let's just say the court decided that she could take that to a jury. And the problem was, going back to my bystander training, the supervisor should have been saying, "Hey, knock this off. What is this? And why does it take a month for them to get the sexually explicit drawings out of the employee locker room," right? That the court is saying, look, I know you don't know who did this, but you should do something about it or try to change. And so in that instance, the court said, I'm going to let the jury decide if she was sexually harassed. Rape bait case. Who thought this was a good idea? I do not know. A middle schooler in Alabama went to complain, and she said, "This guy keeps asking me to have sex in the bathroom. He keeps asking me to have sex in the bathroom." The administrator says, "Well, according to our policy, which is we got to catch him in the act." Yes. So they use her as bait. She gets raped because they don't get there in time. Okay, and I think that they settled that case for $600,000, something like that. Okay, and so look, the idea is, why do we have to catch him in the act? I mean, there's a whole lot of things you can do, like we've been talking about through investigations and what have you, where you don't have to catch him in the act. But that's a real life Alabama case. LGBT students, it is clear from the statistics that LGBT students experience higher rates of sexual harassment and violence than other students. This young man, Seth Walsh, came out as gay in the 6th grade. They were relentlessly hostile to this young man, including it kind of culminated in being in the locker room, and they pulled his pants down, and one guy said he was going to threaten to rape him. He ultimately gets assaulted by 4 students in a park. The allegation was even some of the teachers joined in the disparagement of this young man. Anybody want to guess what happened here? He killed himself when he was 13 years old, and his mother then sued, and she settled it for $750,000. And he was 13 years old when he died. So these things have consequences, right? I mean, these actions, kids can be mean. When my daughter was entering the 6th grade, I told her, I said, "Jordan, 6th graders are the meanest humans on the planet." I said, "We could send them to Afghanistan and end the war, okay? They can be mean." And so there's the responsibility is for the adults to be adults and stop the conduct. Forest Hills Central High School, the OCR ruled that the school failed to properly respond when a girl said she was sexually assaulted in the band room. And what she claimed was the principal discouraged them from filing criminal charges against the boy who was an athlete. Again, like I said, don't discourage them from getting a lawyer. Don't discourage them from going to file a criminal complaint if that's what they want to do. The school didn't protect her from other students, and they dragged their feet in the investigation. And then ultimately the family does file charges, and the boy pled guilty. So this is a case where the OCR says, you know, a K through 12 school is not protecting. The superintendent, of course, disagrees with the Department of Education's, and he says the school immediately called the police and parents when the assault was reported. Something happened here. OCR says you didn't. They said they did. So again, my question would be, I wonder what the document trail looks like, right? What does it really look like? Because you ought to be documenting these things in a way that I've got a record that when we're contacting people. Careers can also be ruined. The assistant dean of UC Berkeley, obviously, she was an assistant. She complained. She goes, look, this guy keeps touching me. He hugs me in an overtly sexual way. I've asked him to stop. I've asked him to stop. The provost allows the dean to stay after they conduct an investigation and find out he's engaging in this creepy behavior. But he only cut his salary for 1 year, required him to write an apology and undergo counseling. And the provost allegedly stated that he didn't terminate him because it would ruin the dean's career and destroy his chances for a higher appointment. They both now have resigned, right? So much for saving his career. Yours went down the tubes as well. Okay, don't drink in Facebook. You ever notice about midnight your Facebook feed starts to get a little crazy? It's like people are, yeah, it's bad. So this is true. This is another case. There were some Facebook comments where a husband and wife said they're making the effing Indian chair. The wife, who was also a professor, said our chair will bring all the hand baskets we need. He's probably woven them himself. The two professors who are engaging in this dialogue get reprimanded. The wife resigns and goes someplace else. The Indian professor submits for tenure 2 years later. The two people who were reprimanded were allowed to vote. His tenure was denied. Any idea what the result was here? So in these cases, our goal is to get this stuff tossed out at summary judgment. That's where it never gets to a jury, right? We say, Judge, believe all the facts they said. As a matter of law, there's no claim. Well, the judge said, yeah, I think there's a claim here, because what we would have been arguing is, hey, 2 years is too long for there to be a causal connection for that retaliation. And the court said the evidence of hostility prevalent in the department, and it provided a causal link between the denial of tenure and his prior complaints, right? And so what the court's saying is that stuff is all still sitting out there, even though it's 2 years old, and it shows you were hostile towards him. This is just another example of, a lot of people want to say to me, well, that happened on social media. We don't need to get involved in that. Well, it can impact the workplace, depending on what the facts and circumstances are. Vance versus Ball State. Now, here's an interesting case. So we had a coworker. So it's coworker, not a supervisor to a subordinate, making comments using the N-word. He was talking about his KKK ties. Called somebody a porch monkey. Then the alleged supervisor. The allegation was that she was mean mugged towards somebody. We never quite figured out what that was. She smiled and blocked the path, and she made comments about Sambo and buckwheat. The school comes in and they do an investigation and they discipline everybody involved, right? Then the employee who made the complaint gets promoted. She still filed a suit, and she tried to claim that the promotion was retaliation. Luckily, the employer won, because the court said, well, you asked for the promotion, and that's a good thing, so that's not retaliation. And since the bad actor was not a supervisor and didn't have the power to direct the terms and conditions of the person's employment, they viewed him as coworkers. And the court said, look, the university promptly and thoroughly investigated it. They took action. Therefore, they're not responsible. So it's not what we call strict liability. If something like bad facts are going to happen in the school, in the workplace, in the schoolhouse, right? The question is, again, how we react to it. What do we do? Do we take action? Things of that nature. So problems can arise when faculty and staff decide that they're going to spend time with students in their residence. I've seen problems. Hold office hours outside of the regular location or in a residence. Drinking alcohol with students. Several cases have come up where faculty members have allowed students to drink alcohol, some of whom have been minors. Bad things can happen. Obviously, if they don't take sexual harassment complaints seriously or do something about it, or back to the bystander issues, if we permit our colleagues or other students or hosts or vendors, anybody in our school community to behave in an inappropriate manner without taking action is when bad things can happen. Individual issues can come up as well. Look, I see a lot of these cases where they'll try to sue the individual, right? In addition to suing the employer or the school, they want to sue the individual. Why do they want to do that? Because that amps everybody up, right? When you are having dinner with your loved ones and the doorbell rings and you walk to the front door and they say, "You've been served," that is the longest walk back to the dinner table that you'll ever have, right? Because your significant other is going to go, "Why are you being sued for sexual harassment in the workplace," right? And so there's other causes of action that can be raised: negligent infliction of emotional distress, intentional infliction of emotional distress, assault, battery, stalking. Many jurisdictions now have stalking statutes. The other thing is the reputational damage. On a slow news day, if a school gets sued, hey, there's the microphone. Tell me what happened. What's what is this sexually charged environment that you guys are dealing with, right? And between all the social media, Me Too, Time's Up, hashtag insert your name here, right? I mean, and this stuff has the ability to go viral in a matter of hours. We even had a situation once that went viral in a matter of hours that we had resolved at a conference. And we didn't know it was going viral till it was all over with, and so it can go quickly. Steubenville, what did not go wrong? A 16-year-old was raped by athletes at an alcohol-fueled party. 2 students get convicted of rape. 6 grand jury indictments have come out. The school superintendent, the elementary school principal, the wrestling coach, a volunteer assistant coach, and the technology director. And the crimes they were charged with: failure to report child abuse, destruction of evidence, tampering with evidence, and obstruction of justice. These indictments just came down. And the technology director was actually indicted for literally destroying evidence. So let's just talk about that for a second, right? If something happens, right, somebody comes and says, "I've been sexually assaulted," like in this case, we don't go delete the emails. We don't go delete the text messages, right? It's all got to see the light of day, because when that happens, the presumption under the law is you're hiding something bad. Right? You're hiding. In a civil case, you can actually get a judge to give the jury an instruction that says you must conclude that they were hiding something bad. So even if you think that email was bad or whatever it is, don't hit the delete key, right? Because now they're bringing criminal charges over it. Okay, so here's another suit involving Holland Christian schools, where it was claimed that they were not following the Title IX rules that were in effect under the Obama guidance, right? Which is a whole other thing, by the way, because the Dear Colleague letter is not really the effective law, but that's what the lawsuit's being brought about, right? And so she...
You might want to clarify, this is not the charter school.
Yes, I'm sorry, yes, my bad.
Examples of the title.
Of
The title's a little
schools,
bit
misleading.
So just so you're...
So the allegation was a 15-year-old was raped by a 17-year-old. He was ultimately sentenced for 3rd-degree criminal sexual conduct. He got 3 years probation. The allegation is that there was repeated requests by the parents to protect their daughter from being in contact with the school during school activities once the allegations were made known. So remember, we talked before about interim measures, right? What did they do to try to separate those 2 students because she kept seeing him? They had no Title IX coordinator, no plan for alleged violations, no investigation, no accommodations or interim remedies. This thing is set for trial. It was supposed to go to trial this month, and it looked like it just got continued, so it's set for trial in 2019.
So this case, and maybe you've heard of the Brighton situation, led to 2 new laws getting passed this year, which allows for a student who's a victim of a sexual assault to actually obtain a personal protective order and prevent that person who the assault was committed by from being in the school, essentially being removed from the school. So very high profile case in the Brighton Public Schools that was part of that. That's now state law. I think it took effect in mid-August. So this case and that Brighton case are what sort of led to that change.
Does the new only yes means yes idea, I think, aren't schools supposed to throw that into their health classes or something? What, do we have any update on?
I don't know the answer to
Only
that.
yes means yes. Okay.
Some universities, and I'm not saying I think this is a good idea, some universities are saying to their students they need to sign an agreement before they engage in sexual conduct so that it's clear that everybody's saying yes. Seems a little bit extreme to me, but it's, yeah.
So one thing, when Don and I talked about this and why we put the role of the authorizer here, just kind of think about this. I mean, what's the easy fix for this problem that was here? I mean, to me, what's the role of the authorizer? What would you have flagged of this when we get down to here?
Right,
No coordinator, no
Here.
policy?
I mean,
right.
so, I mean, the fact that, you know, to me, you know, you're going to, if they've got a Title IX coordinator and they've got a policy and it's being communicated and they have training, a lot of this stuff's going to get taken care of. But that's a huge red flag for you. So, I mean, one thing I would, you know, hope you do and when we leave here is, and I know you do get this, but, you know, we got to have schools have to have Title IX coordinators. It's required by law. They got to have a policy, and it's got to mean something. They got to be doing something. So,
Yeah.
you know, it's one thing to say, wow, we got a Title IX coordinator. It's another thing to have a Title IX coordinator who says, I'm the Title IX coordinator?
Right.
I didn't know that, you know. So I thought that was, you know.
Yeah, and the other piece of that is, the other thing we see is everybody thinks the Title IX coordinator is only for students. And so the faculty and staff and that piece of it gets missed as well. But yeah, this is, like I said to you, and so this case, this is a fairly new case, and they had no Title IX coordinator. Pretty amazing. Another case, similar kind of issue. This was a case where a gal said, I got assigned to my homeroom teacher is a guy who's been making sexual harassment comments toward me, and he'd been disciplined about it. This is a case that's pending as of May of this year. And the allegation is that the school wholly failed to ensure the plaintiff is in a learning environment free of intimidation, harassment, humiliation, gender bias, and other discriminatory and bullying behaviors, and failed to prevent and remedy the sex discrimination or harassment. Go ahead.
All right. Well, so again, role of the authorizer. Right? Lawsuit, right? School's been sued. Most of your contracts require them to disclose to you that they've been sued. If I get a school that has an allegation like this in it, I'm sure going to be asking my field court, you know, my field reps, what's going on in the school, right? I mean, this is you know, I'm taking it at its face of,
Yeah,
you know,
these are allegations.
These are allegations, but to the extent this is happening, you know, we've had this discussion, you know, sometimes they don't report litigation to you. They think, oh, it's going to go away. It's a frivolous complaint. That's not for them to judge under your contracts. That's for them to report to you what's going on in the school. Because if those allegations are true, that's not only criminal, that's potential criminal liability, but also huge civil liability and, you know, potential challenges for the school. If this were a charter school, we'd have a lot of problems.
And if you didn't know about this until it hit the public filings, that's also a bad thing. I mean, that's why I'd be real curious about what kind of communication you're having about these kinds of complaints if they're happening in the school. If you did, I don't know what the contract requires, but I would want to know if I got a demand letter from a lawyer. I'd want these guys to know that.
Yeah, I mean, most of you, I think, have required only complaints. I mean, we've sort of drawn the line. We don't, you know, because you get all kinds of, so if a formal complaint gets filed against a school, a copy ought to make its way to you. I mean, you need to see it. And I've had folks say, well, you know, they get to see, you know, if it's not substantial or it's really not material, and it's not picked up in our audit. That's not the standard under your contracts. The contract requires that all those litigation matters make their way to you so you can understand that. Just like if it's an administrative complaint, if there were a state complaint or a special ed complaint, a lot of you now get copies of those through work from the department, unfortunately. That should be coming from the school. So I think another thing you'd be talking to your schools about is making sure those kinds of reporting get to you. But this is a lawsuit, and that's why we kind of wanted to, you know, that thing would need to get picked up.
Well, and here's the other thing is, this is really hard to fight in the court of public opinion. right? It's hard to kind of stand and answer a press inquiry in a way that is not sometimes sort of bungling, right? It's like, no, we didn't do that. We didn't create a hostile environment. It's very difficult to defend in the court of public opinion because people believe the allegations. So knowledge of rights are expanding on both sides. I used to ask, with the elephant in the room, right? What name do you associate with the most heinous Title IX violations on campus? Just so you don't feel too badly, at USC, George Tyndall was for 30 years the USC gynecologist, and now he has been, there are over 400 people have contacted USC about this guy sexually assaulting women, especially Chinese international students. So, for Penn State, Michigan State, now you got USC. I mean, it's everywhere. Litigation, but though, is also on the rise by respondents. People who are being accused and being dismissed from school are fighting back, saying, "Oh no, you've shifted the balance, and you're more in favor of the accused than you are the respondent." You need to know that a plaintiff is not required to exhaust administrative remedies to pursue an OCR complaint. And what that means is, like under Title IX, under Title VII, you have to file a charge of discrimination and you go through a process. Not required under OCR. They can go straight to the courthouse if they choose to do that. Me Too movement has had an impact on educational educational institutions. It has definitely increased the awareness of everyone about their rights under Title IX. Colorado State University is a professor who is suing them for sexual harassment and retaliation. If you haven't heard of it, the hashtag Time's Up Legal Defense Fund is a fund that is being funded by mostly women in Hollywood and some senior female executives to create a fund to allow people to bring these cases. A lot of times they're brought on a contingency fee, which means the lawyer doesn't get paid unless they settle or they win, right? Well, now in Colorado State, they've given her $100,000 to go pay a lawyer to go sue them straight out of the Me Too movement. Obviously, Chicago public schools are dealing with a huge debacle right now. They're the third largest school district in the United States, and the investigation that they just went through has concluded that there were systematic deficiencies in training, incident reporting, data collection, and trend tracking. Verify is a software program that they use to input when they had these complaints to keep a database of it. When the teachers and the faculty were interviewed, the quote was, "It is almost universally viewed by principals as cumbersome and inefficient." If you've got a process that your school is using to keep this data, and you're hearing from the school leaders, that product stinks. This is terrible. Nobody understands it. We can't use it. Then you need to take a look at what that product is and see if we need to either get training on the product as to how to use it, or do you shift? They had to background check approximately 40,000 employees this summer because they had to background check all these employees because it hadn't been done properly. And they're facing an enormous sex abuse scandal that I think we're only just beginning to hear about.
So let me stop there.
Go.
We talk about criminal background checks all the time, and the whole law keeps changing. We've changed, in the last 4 years, we've had significant changes as to who can have access to the criminal background check information, what information can be shared with a third-party employer. I would encourage you to make sure that not only your folks in the field are up on the policy, but that the schools are up on the policy. And it has changed and it's gotten complicated, but obviously the access to that information, there are specific storage requirements, confidentiality requirements that have been, are still evolving in terms of the information coming out of 3 different departments. And we need to make sure that the schools are up on top of that. So I know, talked to several of you this summer, particularly if you're in new schools that had things to be done, and we need to make sure. And Chicago's a good reminder of why you need to get that done.
So between 2016 and 2017, there were 59 settlements from 22 universities, all in the big 5 major conferences, and those settlements totaled $10.5 million relating to sexual harassment complaints. So these things are getting expensive. I wanted to bring this to your attention because even though the OCR has withdrawn the protection for transgender and sexual preference, here are 3 cases that have kind of come through the works. The first case, in the Grimm case, it actually went all the way up to the Supreme Court, and we thought we were going to get a decision. They actually ended up as to whether transgender students were protected under the law. They sent it back down to the court, and the district court denied the school board's motion to dismiss the complaint because the student was complaining that he was discriminated against under Title IX. And the district court said Title IX's bar on sex discrimination in education includes discrimination on the basis of transgender status. So that's a Court of Appeals decision saying that. Then we've got another Court of Appeals decision out of the Seventh Circuit, the Whitaker case, where the court concluded that excluding a transgender boy from the boys' restroom likely violated Title IX's prohibition against sex discrimination, as well as the Equal Protection Clause. And then the third case that was out there is also Third Circuit unanimously rejected an appeal from a case where a non-transgender child, I think it was a student, he filed suit so that he did not have to use the bath to prevent the transgender from using the boys' bathroom. And they tried to get an injunction because the school was allowing the transgender boy to use the boys' bathroom, the bathroom with which he identified. And the court, the Third Circuit said, look, the injunction was not proper. It should, and the district's policy allowing students to use sex-segregated facilities corresponding to their gender identity was not proper. So in all 3 of those cases, the idea that the transgender student is not protected under Title IX, they were all rejected. So, and those cases are above, obviously, the Department of Education, right? So the law is getting made there. So, in my view, the better approach is those students are protected, and we need to make sure that they're taken care of. Okay, I talked about the importance of communication. I thought since I should pick on Texas, one of the Texas schools too, right? In this case, this young lady reported that her assault within hours after she was assaulted. She went to the Waco police and she saw a nurse at the hospital. Then she goes to the campus police several days later, and they told her they were powerless to do anything about it because the rape occurred off campus. She contacted the Students' Health Center to try to get resources and help and things of that nature, or counseling. She was referred someplace else. They didn't help her there. The family sought assistance from the Academic Services Group because she started to have problems with school. They did not offer any help. Ultimately, she files suit with 3 other women. This in June of 16. This is against Baylor. And the Pepper Hamilton investigation said Baylor and the football program in particular failed to properly respond to the accusation of sexual abuse and dating violence. They just did nothing because it happened off campus, right? And so a little more on the Baylor case, what actually ends up happening is that the young man was criminally charged. He was convicted of rape. And what they learned during the criminal trial, he gets expelled, but what they learned during the criminal trial was Baylor knew of the 3 women who accused the football players of sexual assault or rape, did nothing about it. And they knew, this is interesting, the accused had been, the guy who got convicted had been accused at a community college of engaging in the same behavior. He ultimately gets a 20-year sentence. He's already been convicted. He's in jail. So what happened through the criminal trial is we learned all about what Baylor knew and did nothing about, right? And it's not as big as Nassar, but it's been a mess for them. And there have been several lawsuits have been filed over it. University of Tennessee, another tragic case. They were sued by 6 females, and they were accusing 4 football players of engaging in sexual harassment, sexual assault type of behavior. During the administrative hearings, the accused was entitled to a lawyer. The lawyer was allowed to cross-examine the accused. The same lawyer was used by all the accused students, and so what they believed was UT was helping the students who were accused behind the scenes because they provided a lawyer to the accused. Under the Dear Colleague letter of 2011, this cross-examination of the person who was making the accuser would not have, it was a violation of the Dear Colleague letter. And that's now obviously shifting, and in the Sixth Circuit is shifting. They settled for $2,480,000. So big payout there. This is a different kind of suit. I thought this stuff was so heavy that you actually had to see this. I promise you I'm not making this up. And so there was a physics professor who had a habit of segregating the men and the women in the physics class. And when he was asked by the Title IX coordinator why he did that, he said, physicists are predominantly male. To change this, we try to make the educational environment open to females. Studies have shown that females do better in small lab groups, 3 or 4, that contain more females than males, than more males than females. I train instructors who teach the labs and have told them to rearrange groups as if there's 1 female with 3 males, and if at all possible, to have all female groups. He thought that was a defense to the Title IX allegation. This would be making decisions based upon somebody's gender, right? He's making stereotypical judgments about how women are women going to feel comfortable or not, and the women were complaining about it. You know, you would think he would have kind of clued in there. Okay, basketball player. So this is the other side. Now this is the person who's being accused of the respondent. Here's his allegation. He has filed a suit against Yale, and he said, look, she was pressured into bringing this complaint, all right? And originally it was filed on her behalf by one of the Title IX coordinators. And what they did there is they said they told her he had a prior problem. This wasn't his first discipline. They didn't tell her what it was. They led her to believe that it was related to sexual harassment or sexual assault. What his prior complaint was about is his freshman year had a rolled up piece of paper and put it down a girl's back, down her shirt. And she was led to believe that he engaged in sexual assault. And so the allegation is that shouldn't even come before the hearing, right? Remember I talked about relevant evidence. When do you bring it in? When do you don't? That wasn't a sexual assault. And the guy lost his basketball scholarship. The lawyer, interestingly, says it defies logic and common sense that a victim would return to the bed of a man who victimized her hours before, because that's what happened, right? She goes back to bed with the guy after he says she's sexually assaulted. Remember, he gets kicked out, loses his scholarship. Here's what is some of this science that that we were talking about is going around. Jennifer Long, who is part of a CEO of a nonprofit, right, based regarding sexual violence and victim behavior, she says research has shown there's a range of often unexpected ways that victims cope with trauma. The bottom line is you can't determine whether or not someone is a victim of sexual assault based off their behavior, even though people like to do that, especially the defense. There's an expectation that a victim will be crying and outwardly nervous, but that's not necessarily the case. I don't know where the Yale case is going to end up, but this shows you the dichotomy, right? He's saying, she came back to bed with me. How can she be a victim of a sexual assault? But she's got an expert who's going to say, well, that's because they don't act rationally. And I think that this kind of thing is going to make courts crazy, right? Because courts are going to say, no, you can't just ignore what people's behavior is. There are no easy answers. This is an Occidental case, and this is a series of text messages. John, the second you're away from them, come back. Jane, okay. John, get the F back here. Jane, they're still with me. John, make them leave. Tell them you want to sleep. I don't care, just get back here. Jane, okay, do you have a condom? Yes, says John. Good. Jane says, good, give me 2 minutes. John says, come here. Jane says, coming. John says, good girl, and knock when you're here. That's the text messages. The next day, she claims she was sexually assaulted. And what in this case is a lot of text here, but this comes right out of the case of John Doe's complaint, where the district court said, look, it's very clear that he has rights here too, right? And the facts of the case show Jane Doe was the initiator of the sexual activity and a willing participant throughout the sexual encounter. The sexual assault policy was misapplied. And in this situation where a male student and a female student had sex and both were intoxicated, the college committed an act of gender discrimination by only charging the male students. What has been happening for a while is if they're both intoxicated and they have sex, they only charge the male. Well, here's a district court case saying you're misapplying it. You either got to charge them both or charge none of them at all, right? Occidental found John Doe responsible for sexual assault because as a male, Occidental College considers he is solely responsible for the exercise of poor judgment of both parties, right? So he gets tossed because he exercised poor judgment, and she gets nothing, right? And Miss Doe, let's see. Yeah, and the other complaint in the case was she was really convinced by the staff to bring this complaint against John Doe. And the court said, look, he's immediately treated as guilty. His due process rights were stepped on, and his counterclaim was arbitrarily and summarily dismissed. Because what he does is he said, wait a second, I was sexually assaulted. And some schools will say, I'm not going to let both cases go forward. I say, let them bring it. I mean, you got to figure it out anyway. Why would I make an assumption that his is false and hers is validly to be able to move forward? So in this case, what happened here is, again, remember I said we try to get these things out on summary judgment. The district court said, I'm not dismissing this case. The jury is going to get to decide if his Title IX rights were violated. Brown University, again, another case involving a young man who brought a suit against Brown because he got kicked out of school because of a violation of Title IX. And the court's, interesting, this down on the bottom is a quote from the court. The court may have been following guidance issued by OCR. Remember I said it wasn't the force of law? By removing the plaintiff from campus before he'd been found responsible. But their reliance on OCR did not absolve the institution of the responsibility to follow its own procedures, which guarantee students access to and use of Brown's facilities. So when they took interim measures to say, we're removing you from campus before they found him responsible, the district court here says that's a violation of his Title IX rights, right? So it's a push-pull. But the other thing here is, the courts, here's what courts care about. You don't have to be right. You don't have to figure out really, was there a sexual assault? Was there not? Was it consensual? You have to follow your process, make a good decision, and not be, and therefore you're not arbitrary and capricious. Because you're not a mind reader, right? Many of these are he said, she said. We're never going to know, right? But when you don't follow your own policy, that's when the courts decide you may have more responsibility. Almost to the Supreme Court. So. This is a case where Jane suggests to John that let's go have sex in her bathroom. And so she goes to get a condom, which would suggest to us that there's consent there, and later claims that he sexually assaulted her in the bathroom. The courts found in this case that Columbia did not interview multiple witnesses suggested by John. John said, if you go talk to all these people, we can give you can understand what was going on in the context. What John didn't get found responsible of having forced sexual intercourse with her, what he was found responsible for was coercively pressuring Jane over a period of weeks to have sex. And they failed to go talk to the witnesses and follow up. They also failed to inform John of his rights during the review process. He didn't know he was going to have to give a statement till he showed up at the hearing. And one of the things that sort of the court talks about is some universities and some schools are afraid of the publicity and the fallout from these things. And so, again, they're swinging to say, we're going to make John responsible, even though it was clear that they had consensual intercourse because somehow he pressured her during the course of the week to have sex. And they're saying, no, you can't do that, right? You can't be afraid of the negative publicity because that's discriminating against him because of his gender. Because he's the male, we'll go against him and go with the female. This is the footnotes from the court where the court's kind of talking about this. But the court says, look, a covered university that adopts even temporarily a policy of bias favoring one sex over the other, even if it's doing so to avoid liability, she's going to sue us, or bad publicity, the press is going to be here, has practiced sex discrimination, notwithstanding that the motive for discrimination did not come from ingrained or permanent bias against that particular sex. So what these cases are saying is, just because you're afraid that the female is going to sue you if you don't, find him responsible, is not a reason to find him responsible, because that's discriminating against him based on his gender, right? And so that's how that came out. So how to avoid a PR nightmare? If one of these things happens, if something, the lawsuit gets filed, communication is key in these things, right? I would develop, especially even the authorizers, right? One point of contact for the press to the extent you're going to say anything at all. But you also need to do your homework before responding. Don't, the sort of the off the cuff, I don't think anything went wrong kind of comments can come back to haunt you. Identify all the stakeholders who need to be communicated with. If there's a lawsuit where it says that we've got a predator or a bad person in our school, we need to be communicating with the students. We need to be communicating with their parents, faculty and staff, and potentially alumni, right? Sometimes alumni can be your friend or they can be your foe. I think you've got to balance transparency with confidentiality. No comment sometimes makes you look worse than if you just have some sort of statement that you live by. If you've got an issue, you've got to decide if you've got to issue timely warnings, if you think you've got a predator, criminal trespass warnings. I always tell people, it's interesting to me, they'll post criminal trespass warnings and they post it out where, like it's a letter. Well, I don't know what the person looks like. If you have the person's picture and you're issuing a criminal trespass warning, post the picture so that they can see the person as well. This is a little hard to read, but you probably heard about this in the news. The University of Alabama in their dorm room went on lockdown because this guy was a racist white supremacist. And basically, this text talks about, I'm going to sorority row and, look out because do you want to know how it feels having a TAR 21 passing right through your flesh? I'll be watching all frat parties and monitoring your events. The day is near, be vigilant. That was posted. Parents get wind of it. Again, it goes viral, and the school had no response for hours. So the other message, in addition to if somebody drops a lawsuit, right, have one person, think about this kind of stuff in your crisis management plans, right? If we get some sort of threat, whether it's an instant social media kind of threat like this, who's communicating? Who's going to go talk to the parents? This is something you ought to talk about. What's our crisis management plan, right? How are we getting the authorities there? How are we getting students out? Because they looked really bad from a PR standpoint. I went to Auburn, so I'm happy to point out that the University of Alabama looked really bad. Okay, what would you do in this case? So here you go. You've got two students who have a long-term romance. The relationship comes to an end. They've gone out for about, it came to an end about 18 to 20 months earlier. He starts a new relationship, and the two women confer and discover that he engages in rough sex with them, bruising and all kinds of things like that. He was violent, pushed him up against the dorm walls. 1 year after the relationship ended, and 4 weeks before his graduation, the first girlfriend decides to file a Title IX claim. Later, the second girlfriend decides to file a Title IX claim as well. The accused student was set to graduate summa cum laude, had no disciplinary issues in 4 years, and he lawyers up and takes the fifth in the interview and threatens to sue if he is disciplined for a 2-year-old issue that was never brought forward. Would you guys investigate that? I would. This is actually a real hypothetical. Didn't make it to the courthouse, but I think you've got to. The women actually had picture evidence of the abuse that they had suffered, and all three of these students were foreign students. And so I think the women coming forward, there were some cultural issues as to whether they should come forward and all this kind of stuff. So it was investigated and disciplinary action was taken.
So one thing, and you're probably wondering, why Donna talk about all these university issues, right? It's pretty easy to flip the switch and look at it from a school context, employee to employer, supervisor to employee. They're all in the school context. The reality is, when these Title IX issues start to come up, a lot of the law is being made obviously in the higher ed. But the reality is it's going to work its way down, and it is already, as you've seen, working its way down into K-12. I think the message on a lot of this is going back to having, being prepared, having good policies, being aware of what's going on, understanding what's happening at your schools, and making sure that they have those those processes in place, because this example can easily switch to two teachers.
Right.
Or a third teacher, or a principal.
Well,
And you know,
yeah.
I think that's the hard thing, I think, for some folks who see Title IX and say, well, that's just the university issues. It's not. These are issues that can easily be set and sort of change the facts to be in a K-12 setting.
Yeah, and thanks, because here's my bold prediction. My bold prediction is, first of all, the reason we've had all these cases develop is we got the Dear Colleague letter in 2011, right? So we've had time for these things to work their way through the courts. Now that the Trump administration is pulling back and they're not looking at universities and colleges as hard, I think the target is going to go lower. The reason I think that is because these cases are making law that parents are going to say, well, that applies to us too, right? And you saw the growing cases that have been filed with OCR in the K through 12 space, but you know, it's going to continue to grow. So I think the pendulum's going to switch, especially as we keep hearing all these things of sexual abuse that is getting covered up, right? So I was going to go through some hypotheticals, but we're almost out of time. So let me just wrap it up so we can cut the tape off, and then we can have some more discussion. But what are your takeaways? Is you should be deeply concerned about Title IX compliance. I think it's a real issue. I don't think it's going away. I think that, you know, obviously you got to look at your policies. If they do come out with the rulemaking process, the regulations may change and you might have to make adjustments. Like I said, this is not just a one-time kind of training. I would be thinking about preventive training programs for the students, for the faculty, for the staff. Everybody needs to be educated on the issue. The role of an unbiased investigator is critical in these cases. And obviously, you need a PR strategy if you do have something that happens that's a high-profile case. And so with that, I think we'll end the tape, and I can answer any other questions you guys might have.